Thank you very much for the kind introduction and the invitation. My talk is about common European data spaces under EU law, the state of play, and future perspectives. I will address, first of all, how common European data spaces have emerged, what their specific policy, but also their legal background is. I'll dive a bit deeper into the legal framework of common European data spaces, or CEDS, and which legal tools have already been developed regarding the regulatory compliance and the contractual frameworks, specifically those developed by the Data Space Support Center. I will then highlight what the potential future direction will be, and try to address how we can start to organize the legal way forward, highlighting particular research avenues that we will be foregrounding in the Data Space Support Center, specifically infrastructural perspective, and ways in which data spaces can serve as tools of simplification. So how have common European data spaces emerged? The first policy document that mentions common European data spaces is a 2018 Commission communication, which highlights that reuse of public and private sector data serve as cornerstones of a common European data space, a singular European market for data. And this is then developed further in 2020 through the data strategy, which designates multiple common European data spaces as high-impact projects delivering such a genuine single market for data. It proposes the establishment of 9 sectoral CEDs alongside the European Open Science Cloud. In 2022, a staff working document reports on the state of these CEDs projects. The list grows to 14. At the same time, also the Data Space Support Center is designated as a Digital Europe program action that addresses the horizontal dimension of these CEDs. And in 2024, the staff working document provides a further update. The number further grows, and as one may be able to guess, the role of AI becomes much more relevant. The legal background is quite extensive as well. So data spaces don't have a single Data Spaces Act, but of course data is covered by the GDPR, the Free Flow of Non-Personal Data Regulation, the Open Data Directive. In 2022, we have the Data Governance Act, which addresses data more generally. So the reuse of protected categories of data, data intermediation services, data altruism organizations, and the European Data Innovation Board. And the 2023 Data Act on IoT data sharing, unfair contractual terms, the exceptional use of data, switching of data processing services, and interoperability requirements. Of course, we also have sector-specific law. So in 2025, we have the first data space regulation in the European health data space. So it addresses data sharing rules that are specific to the health sector, specifically primary use and secondary use of electronic health data. There are other initiatives, such as the Financial Data Access Regulation, which have received perhaps less attention. But in a nutshell, the 2022 Data Governance Act was seen as intended as a horizontal legal framework for CEDs, which was not entirely adopted as such. So data intermediation services were seen as a part of developing this European way of disentangling data collection and data use. But data intermediation services are not required for individual common European data spaces. So the overall mission of having a broad horizontal coverage is perhaps less pronounced. Instead, what we see perhaps more directly is in the Data Act, the interoperability requirements do stipulate essential requirements for participants in data spaces, and also provide a legal basis for technical standards and common specifications. So in that way, these interoperability requirements may be probably the most widely applicable provisions regarding common European data spaces. And in that provision, specifically, we also find the first legal definition of common European data spaces, which are purpose or sector-specific or cross-sectoral interoperable frameworks for common standards and practices to share or jointly process data for, inter alia, the development of new products and services, scientific research, or civil society initiatives. Now, this is quite a broad and perhaps more functional definition of a common European data space, but it is the one that we have. And one should say that the general applicable legal framework for data, of course, remains in force. So whether we're talking about existing data protection rules, but also other pre-existing applicable rules, so regarding intellectual property or contracts, for instance. At the same time, it's also in contact with new data legislation, whether that is the, for instance, the Data Governance Act or the sector-specific EHDS. So, to provide an overview, this is the commonly used diagram by the Commission to explain exactly what common European data spaces are. They are covering multiple different sectors. They have particular legal frameworks and normative commitments, such as data pooling. But they also have an important technological component, so regarding the technical tools and interoperability, some sectoral governance mechanisms, but also infrastructural elements such as IT capacity, cloud storage, processing, and services. And this leads me to the legal framework. What is the legal framework for CETS more specifically? Well, luckily, this is not the first iteration of the project that I'm engaged with, and my colleagues at KU Leuven came up with this wonderful spiderweb diagram of all the different legal frameworks that, well, at least quite directly deal with data. So as already mentioned, we have quite a wealth of data-related legislation, and so the Data Governance Act, the Data Act. But of course, there's data governance relevant aspects from the AI Act. There's also more public sector-oriented rules, such as the non-personal data rules of the Open Data Directive, or also the Free Flow of Non-Personal Data Directive, the GDPR, of course, IP rights, particularly in there, and also trade secrets and copyright, and the EU's own sui generis database right. Of course, we have applicable contract law, consumer law principles apply where the consumer data, for instance, is at stake. We have sectoral legislation. Well, of course, the EHDS, the European Health Data Space, is the most prominent example thereof. But also at the same time, we have relevant rules coming from cybersecurity law, and of course, the platform regulation and competition law continue to apply where those regulatory regimes apply to actors or practices within sets. So it's quite a network of different regulatory frameworks, and of course, this doesn't make necessarily it easy to come up with comprehensive legal tools, but this is exactly what the DSSC has attempted to do. So I will highlight a few aspects of what the DSSC has come up with. So the DSSC has developed a blueprint with particular building blocks for how to exactly foster data transactions between data space participants. So within this operational definition that the blueprint creates, the focus really is on enabling trusted data transactions between the participants of a data space. So it's more functional, perhaps, than the legal definition we have in the Data Act. And to that end, it outlines building blocks that determine a given capability for a data space, which are divided broadly into business and organizational and technical. But within that framework, of course, you have to raise different questions. So the business side may focus more on value creation and financial sustainability, whereas governance dimensions also focus on organizational matters. But of course, on the legal side, the focus is on regulation, on contracts, and agreements between participants, but also the initiators of a data space. So some aspects of the governance building blocks also deal quite directly with the organizational form. So the questions that need to be asked, okay, do we actually need to create a legal entity? Do we not? What type of legal entity? Which guarantees the type of governance framework that we want for sharing data, which then of course touches on fundamental principles also of corporate law. There may be some particular governance frameworks, so how to manage different participants, who has which powers, who has particular duties, how to manage those different relations between participants, and who has particular rights within data transactions, whether there's certain default rules, for instance. But from the more specific legal building block side, there's of course there's a broader question of applicable law which needs to be raised, and this is something that requires also a bit of a case-by-case touch. And of course, this leads into the conversation about which technical parts of the data space can contribute to that. So RegTech is a term that comes up in this conversation as well. And of course, from the contractual side of things, you have to understand exactly which kind of agreements are possible within the data space in the first place, which type of data usage scenarios, which data access scenarios can be described within a contractual framework, and which elements may be already covered by the governance framework I already mentioned. So that is quite detailed, but the important aspect I would want to highlight here is that these building blocks they are quite conceptual. They are organized within this blueprint to define the particular capabilities that a data space should enable within all manner of types of relations between business to business, business to consumer, potentially business to government. All these different types of relations should be potentially covered by these building blocks, and they define what the data space should be able to achieve. And then on the other hand, we have tools. So these are particular implementations that are already perhaps being used within data sharing ecosystems of all different types within the EU, but also beyond. So the building blocks, they specify what the data space functionalities and requirements are. Then there's maybe some intermediate components that specify how these materialize, and then a toolbox, which you are free to access on the DSSC website, is a distinct catalog of these individual technologies, these individual interoperable standards, for instance, and these have then particular relationship between they reflect a particular relationship to the building blocks in the blueprint and how they can be implemented. But there are some changes coming. So this is the current state of the affair of how we can approach SEDS these how they can be created. There's also something about a co-creation method that I've left out that ties this together. But at least in light of the 2025 Data Union strategy, we will probably see quite a number of changes to the configuration of SEDS, also from the legal perspective, but also from the technological side, from the building blocks, from the tools that are enabled. And this is particularly noteworthy with this strategy, which really shifts the focus of SEDS. So as you may be able to tell from Pillar 1, the access to data is really geared towards AI and innovation. So the idea is that we will scale up SEDS, and that through initiatives such as data labs, which provide particular services, pseudonymization, anonymization, synthetic data generation, that more data will also be available for AI development, for instance. There's also a forthcoming Cloud and AI Development Act, and it also foregrounds the value of particular strategic data assets. So in the public sector, scientific data, cultural data, and linguistic resources. For Pillar 2 also targets the legal framework quite directly. So it's aimed at what I mentioned with the Data Governance Act and the Data Act, for instance, but not only, it's also aimed at changing that and reforming that whole package of data legislation, or also called this the data acquis. There's also initiatives to future-proof the data framework, to develop what, especially for businesses, something that what the Commission has called one-click compliance. So making it easier for business to enter and also be legally reinforced, but in their interactions within a data space. And finally, also there's some initiatives to help businesses comply with the Data Act. And Pillar 3, I think, is also maybe perhaps the more geopolitical aspect of the data union strategy, which is targeted at safeguarding the EU's data sovereignty at an international level. So this is targeted at cross-border data flows, at linking with particular third-party countries, or third countries in the EU law jargon, and of course boosting the EU's standing within the global landscape. There's some obvious aspects from the other pillars that also have some legal dimensions. I touched upon the data labs, which of course with pseudonymization and anonymization raise data protection questions. The Cloud and AI Development Act is of course a legal act as well. But I will focus on Pillar 2, so what potential impacts the streamlining of data rules may have for the makeup of data spaces more generally. And I apologize in advance for the next slide because it is a bit in depth, but basically what streamlining data rules means for from the perspective of the data union strategy is to, as I mentioned, simplify the EU's data acquis. So we actually, at the same time, so this came out in November 2025, the Commission also proposed the Digital Omnibus regulation. I'm sure maybe some of you will have heard of the Omnibus also for AI. So these are twin proposals. And the Digital Omnibus, the standard Digital Omnibus is also quite extensive. It repeals the free flow of non-personal data regulation, moves some of those rules. It moves some of the DGA rules to the Data Act. It consolidates public sector data sharing rules. It modernizes EU e-privacy rules. It makes some changes also to data protection law, so the GDPR, to make it more innovation friendly. And of course, it also makes some more minor, but also still significant amendments to the Data Act, and also extends the protection for SMEs. But this is not all. So the second ambition within this pillar is this future-proof approach. So the Commission is also carrying out a digital fitness check, so to identify further areas where changes to the law may be necessary. So, and also covering sectoral aspects. It's also looking to further modernize digital legislation and data protection. And interestingly, it also wants to address some more opaque aspects of data brokerage. So finding out exactly what happens with data once it's been subject to economic dynamics. One-click compliance is also quite interesting. So this is another proposal that was, there were three proposals that were accompanying this strategy. Is the European Business Wallet Regulation, which basically is trying to do what perhaps you've heard of, the digital product passport regulation. This is trying to do something quite similar to that, but for businesses regarding attestations such as compliance certificates. And for assisting business compliance under the Data Act, the Commission also proposed some model contractual terms for data sharing, also at a horizontal level. So for any type of voluntary data sharing agreements, which is quite large. It also covers, for instance, IP arrangements between a data sharer and a data recipient. And there's further guidelines and guidance planned that we will see in due course. But yeah, that brings me to the crux of the issue. So, what is the impact of the data union strategy? Well, some of this is, of course, difficult to reach a verdict on at this time, especially since the digital omnibus is still in the legislative procedure. But of course, it's quite directly going to affect exactly the structure of the spiderweb diagram. Who exactly, which exact arms will be cut off, or which ones will be, maybe tied into a knot. But this is of course going to be an ongoing process. So regarding also the digital fitness check, this may further change. We may have to add entirely new ones like the business wallet. But also, I would want to highlight that this has, of course, concrete impacts on the dynamics of the common European data spaces, which follow particular building blocks of the blueprints and the particular technical tools, but also legal tools and governance tools that implement those building blocks. So I've just highlighted one potential example. So the European Business Wallet, for instance, it introduces an entirely new regulation to this spiderweb diagram. It would be a new arm, but of course that then requires understanding what exactly new building block is needed within a blueprint, and which new tools are needed to reflect that building block, and also make the business wallet come into fruition. So this is quite a starting point, to say the least. So what we are doing now at the moment from the legal perspective is to try to understand how to organize a legal way forward, and also in terms of legal analysis. So there's two dimensions to what we are currently starting to do. So we are investigating an infrastructural lens for coherence to recognize sets as a digital infrastructure, not just for data sharing, but also for all types of informational exchanges. So to see the role of certain tools that may be part of the toolbox now, but also maybe in the future, or of certain actors. So there may be certain actors within the data space, also subject to the governance structure, such as governance authorities within sets that act as an infrastructural actor. So collectively, the rules that apply to sets can be clustered, maybe to address some of the barriers that make it currently quite difficult exactly to parse which part of the legal framework has which relation to with a building block or a tool or another type of aspect of relations within data spaces. And the other is to see sets as a potential tool for assisting also in simplification. So where does the law enable particular mechanisms already, and where are these new mechanisms emerging? So clarifying exactly what the role of some of the technologies of sets is from a legal perspective. So to also develop a bit more of a practical understanding of, okay, what is the role of a particular technology, and from the law. So to give you a bit of a insight into this, so an infrastructural lens for us means that infrastructures are also can broadly seen as foundations for data transactions. So the infrastructures we see as fundamentally relational, and this is of course also in mind with the fact that common European data spaces are focused on transactions of data, which don't need to necessarily be fully commercial, but they can be of any different type of nature. They may have a tendency to have a network form, which is also reflected, I think, by the more the broader scheme of data space architecture. They tend to be pervasive, and they also, of course, enable other potentially dependent activities. And I think that is also quite directly the objective of enabling data sharing for greater AI development. So the idea is that this clustering of different legal frameworks can reveal more commonalities across sets. So there may be already some common regulatory features that are in the applicable law to sets. So I've done some work with Charlotte Ducroix on the commonalities between data processing services, data intermediation services, flops and gatekeepers, and the DGA, the Data Act, the DGA, the DSA, and the DMA, for instance. And from the perspective of simplification, we can of course analyze specifically what the role of compliance mechanisms is from a legal perspective. So there may be some uncertainties that exist within this exercise, but there are some applicable rules that are still coming to fruition that may provide some important guidance. So, for instance, cybersecurity rules. But there's also further rules that are already on the books, but are becoming more and more significant. I'm looking especially at the Data Act rules, which are not being amended under the omnibus. But for instance, in Article 11, we have rules on technical protection measures, and Article 33 is this interoperability framework for standardization regarding data spaces. But of course, there's also new developments such as the European Business Wallet that I mentioned earlier. So, what exactly the relationship between these emerging but also existing legal frameworks is can perhaps provide some answers on which exact mechanisms are useful within a data space. So to summarize, I'm also very much looking forward to elaborating a few of those points. CEDs have played a quite crucial role in the recent EU legal and policy environment concerning data. And with the recent data union strategy, the EU is, of course, significantly adjusting both the policy approach and the legal framework for data. So this is especially true via the digital omnibus proposal, but there's further measures that are being taken: digital fitness check, the European Business Wallet, also the model contractual terms. So we find that studying CEDs becomes quite essential, also from the perspective of viewing them as digital infrastructure, as within the broader framework of the digital environment, but also of the data economy. The legal framework is changing and quite dynamic, but it also can deliver some useful benefits, not just for businesses but for society as a whole. So in terms of simplification, but also, of course, at the same time, we need to understand exactly what the implications of CEDs and these regulatory shifting dynamics are. So, especially for EU values, for democracy and fundamental rights, because of these interests that are being pursued, especially regarding AI and innovation. So, with that, I like to thank you for your attention and look forward to the Q&A.